It is the day of your final hearing, your actual trial. You're back in a large courtroom full of people, and you notice the officer who ticketed you sitting and waiting for your case to be called. It is now clear that you're going to have to do the hearing because the officer is there. There is no possibility of an easy win just because you showed up and the officer did not. Let's imagine that you're not so comfortable about going to trial or having to speak before the judge and so many people, but you don't want to pay the entire ticket and the court costs, and you do not want to have all those points on your license. Is there anything you can do other than going on with the trial?
Plea bargaining is allowed in traffic cases. Go talk to the officer and ask for a reduction in the charges. This can actually work out to the benefit of everyone concerned. We'll explain why in just a moment. For almost everyone, the first step is just walking up to and starting a conversation with the police officer who gave you the ticket. You may not have had a pleasant experience when you got the ticket, and perhaps you might not have been so nice to the officer. This is all the more reason to engage the officer in conversation. You could even break the ice by offering an apology for any hard feelings you might have caused. Even if the officer refuses to negotiate, you may at least have eased the situation. Don't be surprised if the officer fails to recognize you or make eye contact. Police officers ticket a lot of people. In addition, they can be just as nervous or cautious about starting a conversation as you might be. If they see you are a decent person to deal with, your outcome in court might be better for you.
Here are some reasons why an officer may willingly offer a plea bargain. Perhaps the officer needs to get back to work, and it would be worth it if a trial is avoided by your taking a plea to a lesser charge so that everyone can get out of court more quickly. Perhaps the officer has lost his or her notes and is not feeling so good about the chances of winning at trial either. Once in a while, not often, but once in a while, the officer may have made an error on the ticket. This would mean that you have a decent case and possibly there is a deal to work out. For example, you may have gone to court angry that the ticket was for going 52 miles an hour in a 35 mile an hour zone when you think you're in a 45 mile an hour zone. Perhaps the officer agrees and you plead to the reduced charge of speeding only 7 miles an hour over a 45 mile an hour limit. Everyone goes home early, you get fewer points assessed, and you did not risk losing your case in a trial. Moreover, if all the facts were presented, the judge might well have convicted you of the lesser charge anyway.
The suggestion is that you show your best side and try to see things from the officer's side when you are hoping to reach a deal. Neither the officer nor you may lose anything in making a deal. An error can simply be corrected, and everyone's time is saved. Let's look at another example of how plea bargaining can work. Suppose you find yourself in court on a 4-point speeding ticket. It could have been reduced to a 2-point ticket if you had been able to pay it on time. Traffic safety is the true focus of many police officers. If you explain your financial hardship, you may be lucky enough to have a ticketing officer who will plead your ticket down to a 2-point offense. The officer has not given anything up in terms of the number of points on your license that the ticket was expected to result in. You've had to pay the court costs as well as the fine, but at least you don't have the full number of points on your record, and maybe have more time to pay the fine and court costs.
The bottom line is that there is little to be lost and perhaps something to be gained by talking to the police officer. If you cannot deal with the idea of talking to the police officer and you are in a situation where you might lose your driving privilege if you lose the case, think about whether you want to take a lawyer to represent you at the final hearing. Even though plea bargaining is permitted by the rules for traffic infractions, some law enforcement agencies have a policy requiring their officers to go to the hearing or trial on the original charges and not plea bargain at all. If there's no deal to be had, then you will need to wait your turn and have your hearing. That means it is time to review all of the work you did to prepare for the trial. It is also time to ask the officer for discovery. We'll explain discovery in this video. Rule 11B, Final Hearing. The order of proceedings at the final hearing shall be as follows. 1. Before commencement of the hearing, the referee shall briefly describe and explain the purposes and procedures of the hearing. 2. The officer shall offer sworn testimony and evidence to the facts concerning the alleged infraction. After such testimony, the referee and the defendant or counsel may examine the officer. 3. The defendant may offer sworn testimony and evidence and shall answer questions if such testimony is offered as may be asked by the referee. 4. If the testimony of additional witnesses is offered, the order of testimony and the extent of questioning shall be within the discretion of the referee. 5. Upon the conclusion of such testimony and examination, the referee may further examine or allow examination and rebuttal testimony and evidence as deemed appropriate. 6. At the conclusion of all testimony and examination, the defendant or counsel shall be permitted to make a closing statement. C. The Colorado Rules of Evidence do not apply to hearings under these rules. Traffic infraction hearings, or trials, in the state of Colorado courts are one of the few parts of the legal system designed for situations where neither side is likely to be represented by a lawyer. Remember, it is the officer who ticketed you who prosecutes you, not the district attorney. The hearings are supposed to be informal in all cases. Another thing that makes the hearings different than you might expect is there's no jury, and the judge can ask questions and take testimony so long as the judge remains neutral and neither side is favored by questioning from the judge.
As explained in the first video, things may be different in municipal courts. The focus of this video is the county courts of the state of Colorado, not the municipal courts. You are responsible for finding out the rules for the court you are in. In county courts, before the hearing begins, the judge explains the purposes and procedures of the hearing or trial.
The step-by-step procedure is as follows. When the hearing begins, the police officer swears to tell the truth and then gives his or her side of the story and says what he or she saw. After this, the judge and you may each ask the police officer questions. Next, if you choose to testify, you swear to tell the truth and give your side of the story. This means that if you choose to testify, you're giving up your right to remain silent, and the judge can ask you questions, although the officer cannot. More about whether you should testify later.
After both the officer and the defendant, you, have testified, either can add more testimony of additional witnesses, but the judge can limit the order and amount of such testimony. After both sides have presented their versions of what happened, the judge can ask for more testimony. At the very end, you as the defendant are permitted to make a closing statement. This is not a time to talk about or tell more about what happened, but it does let you summarize what the judge has heard. Tell the judge why you should win the case. Prepare to give your best on the day of the trial. Make no mistake, final hearings are trials. They are one-shot deals where each side gets to present its side of the story one time only. They are not everyday conversations. The judge has to let you give your side, but doesn't have to and may not ask questions or help you present things you forgot to say. A judge can do that, but is not supposed to help either side out. You need to go to your hearing or trial very prepared.
Discovery is the legal term for getting to see the other side's evidence or story before they show it. The rules forbid you from seeing any materials the officer plans to use before the final hearing, but on the day of the final hearing, you're entitled to see all documents prepared by the officer which the officer intends to use. Because police officers issue so many traffic tickets, they can rarely present their case from memory. They will often read from notes they made on the back of the ticket. You should be able to see the copy they gave you. If speeding was involved, they may have technical data for the laser or radar unit used to measure your speed. They may also present written information about their training or certification on how to use the equipment, for instance, how they used a speed gun.
This is another reason for talking to the officer before the hearing, to review all the documents prepared by the officer that the officer intends to use. Tell the judge if the officer won't let you see what he or she plans to use at the hearing. Also, don't be surprised if the judge requires you to show the officer anything you brought to use in your own defense. You should bring anything you think may be helpful in proving your case. If you think traffic signage was missing or unclear, perhaps bring photographs or pictures of the area where you were stopped. If the traffic signal was not cycling properly, perhaps you have that captured on a video. Perhaps you will produce a map of the intersection showing where you think you and other vehicles were placed. You are allowed to bring witnesses. Ask the court to issue a subpoena, a court order, for a person to come to court or for the production of documents at the final hearing. If you want to have subpoenas issued, the details of how to do this are included in a link below this video. You can only subpoena documents at the final hearing. This is not a tool for getting information in advance of the final hearing. If you want to subpoena documents or individuals to testify, you must ask the court for a subpoena well in advance of your final hearing.
In every case, get yourself a copy of the law the officer complains that you have violated. The citation to the law, meaning its statute number, will be on the ticket you were given. If it is a law of the state of Colorado, you will be able to find that online or in hard copy in the state statute books at your local public library. Ask a librarian for help or go to the self-help center in a courthouse. County ordinances and municipal codes can be harder to find, but they're often online or available at the courthouse where your case will be heard. Once you have found the law, read it, as it may not be what you expect. Some traffic offenses are what are called strict liability offenses, meaning the officer does not have to prove that you had any knowledge or bad intention or meant to do anything wrong, like speeding. If your only defense is, I didn't know that I was speeding, or that I thought I stopped at the stop sign, you will lose if the judge thinks you were speeding or that you rolled through the stop sign. Some people are surprised that it does not matter whether they knew they were doing the wrong thing or not.
Other laws give you some room to explain why what you were doing was reasonable and not wrong in the circumstances you were in. If you are convinced your speed was reasonable and prudent, that is, not too fast for the traffic, or that your lane change was done in a safe manner that kept everyone else safe on the road, you may have some room to present the case to the judge. Focus on why you thought what you were doing was okay. This video cannot be specific to your circumstances. Get legal advice from a lawyer if you need help, or decide to do your best with your own reading of the law and what it says and means. It is generally worth finding out what the law is and understanding it to the best of your ability. After you read through the law, you may decide that you were wrong and decide not to fight the ticket. Alternatively, understanding the law may help you focus on why the officer was wrong and therefore how to explain to the judge why you should win.
Another reason for going to the library and getting a copy of the law is that you may find yourself charged with something that does not match the facts of the case. If so, then you should ask the judge to rule for you. The officer may write the wrong code section on the ticket. Although this doesn't happen very often, only every once in a while, basic due process means that the ticket should give you notice of what you're charged with doing wrong. That is exactly what law you broke. If the ticket was wrong, tell the judge. Finally, Write out your story. Either use the written story to help you with what you tell the judge, or if you are nervous about telling your side of the case, you may simply want to read it. Writing things out may organize your story so that you can look the judge in the eye and tell your story from the heart.
Even though traffic infraction cases are considered civil cases, not really a criminal case, the standard of proof the prosecuting officer has to meet is proof beyond a reasonable doubt, which is a very tough standard.
When the officer presents his or her version of what happened, listen carefully to what is said. It may sound like a lot of unnecessary detail to you, but the officer is supposed to give evidence about the date, the time, and the location of the offense and show the court that what you did wrong happened in the city or county of the court's jurisdiction. The officer also needs to prove that you did it, not someone else. So if the officer says the defendant was identified at the scene by the driver's license, but fails to also say that the driver was you, the defendant sitting in the courtroom, you may be able to argue that the officer did not prove that you did it. Also, the officer has to say in detail why what you did violated the law written on the ticket. You will only know if it's been done right if you've looked up the law and compared it to the ticket.
The case against you, the one that has to be proven beyond a reasonable doubt, is made once the officer has finished both testifying or telling his or her side of the story and answering any questions asked by you or the judge.
If the officer has left anything out, an unbiased judge is not going to complete the officer's prosecution case by asking the officer questions to fill in the missing pieces. But a fair judge will not tell you that there was anything wrong with the officer's case either. Let's consider the situation where the officer has failed to say that you, the defendant, sitting in court, were the person who was issued the ticket. If you then choose to testify that you remember the officer and you were there at the time of this violation, you will have given the judge the missing information and perhaps let the judge find you guilty, when you could have won by not saying anything. You may not even know that this has happened. This is one reason why people hire lawyers who will ask the judge to dismiss the case when the prosecutor's case fails, before letting their client say anything and possibly filling in the missing pieces of the officer's case.
Once the officer has finished, the judge will ask you if you wish to present your side of the story or testify. The judge should remind you that you have an important right not to incriminate yourself and can remain silent and not say anything at all. This risk of offering testimony that might help the officer was described in the previous example about not supplying missing identifying evidence. This is where understanding the law and your rights can be very important. If you think the officer's case failed for any reason, ask the judge to dismiss the case against you. Explain your reasons as best you can. Do this before giving your side of the story or testifying. If the judge denies your motion to dismiss, then you have to decide whether to testify. If you choose not to tell your side of the story, you choose not to testify, the judge should still let you make a closing statement. But this is not the time to offer new evidence. If you want to give new facts to the judge to consider, you're going to have to give up your right not to testify. You may also have to answer any questions that are asked by the judge. Most defendants want to testify, and this may be true of you, particularly if you've put a lot of effort into preparing your case. Especially in cases where your guilt or innocence hinges on whether what you did was reasonable, it's usually a good idea to provide a defense stating in detail the reasons why you think your actions were safe and reasonable, assuming that this is your true belief. You don't have to disprove what the officer said. All you need to do is make the judge have doubt about the officer's statements and reasons why your actions were not reasonable or safe.
For example, Perhaps you were charged with following another vehicle too closely, and the officer failed to give any testimony about the traffic behind you. Perhaps you felt you were doing the best you could because someone was tailgating you, and to slow down would not have been safe. Give as much detail as you can so the judge can be helped to feel that your testimony is true and accurate. Simply saying there was another vehicle behind you may not be enough to convince the judge to doubt and to not believe the officer. You can, of course, simply say you did not do what the officer said you did. You should not lie, and indeed that would be a serious offense itself for which you could be jailed. However, suppose the officer put in the wrong date on the ticket, you can honestly say that you did not do it on the date charged. Perhaps you can show that you were out of town that week. Again, get some legal help if you think you need it. The judge will give you the last word before making a decision. This is your closing statement. It is the time to carefully summarize and tell the judge why the judge can and should have reasonable doubts about whether you did or did not do what the officer said you did. Focus on why you should win.
Even if you believe it, resist saying the officer was not fair. Perhaps everyone was speeding that day. Officers can only stop one vehicle at a time, and they have to decide which car, truck, or motorcycle to stop. Don't focus on how fast other cars were going unless it really matters to what you did, like following too closely, because your only hope is to create doubt in the judge's mind about whether you did what the officer said you did. If, as part of your story, you say you and everyone else was speeding, you've simply made the judge's decision easy. You were speeding. If you think you have been discriminated against or treated unfairly, save that for another day and get some help about how to submit a complaint. Your traffic case has you in the hot seat, not the officer. It is not the time or place to complain about the police.
Once you have finished, the judge will make a decision. If it is not guilty or not liable for the infraction, you get to go home free, meaning no costs or points. If you are found guilty or liable, you'll be given instructions on how to pay the fine and costs. In most courts, you'll be expected to pay in full that day, usually at the clerk's office counter. If you think you qualify as poor or low income, make that known to the judge and see if any of the fees could be waived or written off. In traffic cases, the penalties and costs are fixed, meaning the judge usually has no ability to change the fine, but there can be some leeway, especially on the costs.
Even if you're angry about the outcome, try not to take it out on the court staff. If you think the judge made the wrong decision, you can appeal. Court staff can give you some explanation of how to do that. For more information, check out the links below this video.